I do want to thank you all for taking time out of your Saturday to come visit with us, and here we'll have an opportunity for you to ask questions if you'll let me get through my prepared remarks about thinking about getting married or married, and then we'll have a Q&A period then. I'll introduce you to Judy Sherman, who was so kind to make this road trip with us, and she'll give you some helpful hints about your financial foundation. We'll have Q&A after that, and we can open up and talk about whatever y'all want to talk about. Before we get to that, I just want to get a show of hands. How many of you are married? Oh, excellent. How many of you are thinking about getting married? Okay, great. So you happen to know, as a married couple, where did y'all go to get married? Canada,
California,
New York.
New York. Okay, so all over the country and out of North America, out of the country to Canada. Love Canada. Not so crazy about the Ted Cruz from Canada, but like the polar vortex, this too shall pass. So, as you might know, you might be married in Canada, but Texas doesn't care. You are legally strangers in the eyes of the great state of Texas. So we're going to talk about the impact of your marriage, if you're thinking about getting married, what that means to you now, and what you can do to create a legal relationship between you and your partner/spouse. So Texas doesn't care. We need to talk about protecting ourselves. And to start, I think it's a good place to start and talk about, this has been the gay year. I mean, we've had so many things that have happened in 2013. I kind of hate to bring in the new year, except I think greater things are coming.
Yes.
So let's go back to June of last year when the Supreme Court in the Windsor decision, to give you a little background about Windsor, everybody familiar about the Windsor case? I mean, people don't realize in the general population that we intensely follow these cases because they have such a profound impact on our lives.
Yes.
But Edie Windsor and her partner of many, many years at the time went to Canada and got married when it was legal in Canada. And then Thea Spire, her spouse, then they moved back, they lived in New York. They went to Canada, got married, came back to New York. Thea had a will that left everything to Edie, and when she died, Edie inherited everything and got smacked with this huge estate tax because the federal government didn't recognize their marriage. Had they been a married couple, it never would have happened. So that was the context of the case that went to the Supreme Court, the United States versus Windsor case. And in that case, the state of New York had said, I'm sorry, but you are strangers in the eyes of the law, and so you have to pay this United States estate tax of $363,000 because of the so-called Defense of Marriage Act, DOMA. So DOMA's decision was directly on point in front of the United States Supreme Court. And just so you know about it, the so-called DOMA is actually 3 sections. That's it. That's the entire act right there. And the first is the title. And then the second 2 sections, the first big paragraph talks about powers reserved to the states. And that says, as you'll notice, that no state or other territory of the United States or Indian tribe shall be required to give effect to any public act, record, judicial proceeding, or of any other state, territory, possession, or tribe, respecting the relationship between persons of the same sex that is treated as a marriage under the laws of such other state. In other words, this is kind of, if you think about this, this is kind of a parallel prohibition. That one state need not recognize a valid marriage between a same-sex couple coming from another state. But the third provision is the one that the Supreme Court was addressing, and that's the definition of marriage for, think vertical, for federal government purposes. And that's the section that says, in determining the meaning of any act of Congress or any ruling, regulation, interpretation, etc., between agencies of the United States, the word marriage means only a legal union between one man and one woman as husband and wife, and the word spouse refers only to a person of the opposite sex as husband and wife. So this is the federal law that the United States Supreme Court heard, and the argument was, I don't know if you knew, that's unconstitutional. So the Supreme Court, much to Harry's chagrin, struck the paragraph 3 of DOMA. What that means is that the federal government will not only honor your marriage, but you, if you are legally married in any state or foreign country that recognizes your marriage, the federal government says you are entitled to 1,138 rights that attach to your marriage license. Congratulations. The thing that a lot of people don't understand, and the media certainly doesn't focus on it, is that Section 2 of DOMA is still the law of the land. And that's why we have, essentially, it's separate and unequal states. And the great state of Texas, as you can imagine, is on the side that is going to uphold this until their last dying breath. At least the cronies of Rick Perry's that are in the state legislature and the government right now in Texas. I'm longing for the days of the Ann Richards and the Barbara Jordans and the LBJs who are all about expansive rights and equality. But presently, this says that Texas is not required to recognize your Canadian, your New York marriage, or anywhere else you might want to get married. Marty and I got married in D.C. in October. After 17 years together, she finally said yes. I know, she's smiling. You said it 17 years ago, and I'm so grateful that you did. And we just finally got the license that went along with the marriage celebration we had 17 years ago. So, where can you go to get married? There are right now, you've probably been keeping up with this, most of the LGBT audiences that I see do already know that there are 17 states and the District of Columbia in the United States that will recognize your marriage, and you can go to any of these states and be married. It was Utah for a few brief days in December, and the home of the Mormons. I think this is just so mind-blowing to me that the court came down as strongly as it did in favor of marriage rights there, but that's been stayed by the United States Supreme Court because Section 3 of DOMA was tossed last summer. Section 2, where one state doesn't have to recognize the laws of another state, has not been decided by the Supreme Court. That's why the Supreme Court granted the stay, because that issue was not before them last June. And that's the posture of the next part that will end up before the Supreme Court to be heard and say whether or not one state has to recognize a valid marriage from another. We've got a federal judge in Utah that tossed out the Utah ban against same-sex marriage. And there are already cases pending in Texas challenging the constitutionality of, Texas actually has a belt and suspenders approach to try to write us out of the state constitution. They've got a constitutional amendment in the state constitution as well as a statute on the books in Texas that says, no, are you not married? Hell no, you're not married, and we're not ever going to recognize you as married unless you're an opposite-sex couple. So there are right now 2 cases pending in Texas challenging the constitutionality of that provision based on the Supreme Court's decision in Windsor. But that wasn't before. So we will see what happens in that case. However, this map is constantly expanding. What a lot of people don't realize, you see the dark states on there? Those are the states that will give you all of the 1,138 rights that go with your marriage license. There are some kind of beige-colored states, and those that will give you either domestic partner or some other civil union type of recognition for your relationship. But be aware that the Supreme Court is not going to, or the statutes in the federal government is not going to recognize either a civil union or a domestic partnership with the same type of rights that a marriage can have. So you might want to think about tying the knot if you're serious enough to be unionized, you're serious enough to say, I do in one of these states. Just a caution, because some people wonder if they're protected if they've been civilly unionized. As you may know, one of the most recent states, New Mexico, our neighbor to the west, by unanimous court decision, said that there's no reason why a same-sex couple shouldn't enjoy all the same legal rights as an opposite-sex couple. So, by unanimous court decision. It's amazing. Do you know that half of the states on that map have voted or had judicial decisions in favor of marriage equality just in the last 12 months? So it is just a phenomenal turn of the tide, if you will, toward equality and toward marriage equality. And I have every reason to believe that we're not through yet. So, there are 2 factors that you need to look at if you do live in one of the states like Texas and you've gone somewhere else and gotten married, you've come back to Texas and you understand you're single, right? So you have to look at whether or not you're going to get any of those federal rights, or do you have to go live in New York or Canada or New Mexico or wherever else. So we're going to talk about this test. And the first is, your marriage state, the state of celebration sometimes, where you're domiciled, where you claim your home. Right now, I'm assuming that all of you who have gone somewhere else and gotten married are Texans. And you took a trip and you went either to Canada, New York, or like we did to D.C., and got married and came back to Texas, yes?
Yes.
Anybody that moved here, that been married like in New York and moved here or anything? Okay. So, our state of domicile is Texas. So, one factor that we're going to look at in just a minute is whether or not you live in a recognition state. We don't. We live in an NRS, a non-recognition state. The other factor is what federal agency are we talking about to see whether or not we living in a non-recognition state are going to be entitled to any of those marriage rights. So, using these two factors, let's look at some of the 1,138 rights that apply to that married couple in the marriage license. This is so tiny. I didn't do very good with these colors, did I? Can you read that? No. So, I'll read it to you. If you live and marry in a recognition state, you can imagine, you get full equality. So the couples who get married in New York and continue to live in New York, they get all of the New York benefits because you do in the state of New York have New York rights now, as well as all of the federal government rights that you get from the federal 1,138 laws that impact marriage. So they get full equality. That's like in New York. If, however, you lived in New York, got married in a recognition state, and now you're in Texas, then you have to go to the second part of the test. It's a two-part factor test, and that is, what agency are we talking about? If you live in a non-recognition state like Texas, what agency are we considering to see if the rights apply to you? These, you'll be happy to know, the Department of Justice, the Department of Defense, Homeland Security, these agencies already give you all of those rights even in Texas. Even in Texas, if you work for the military, it took a little handling, but if you are in the military, your spouse is now entitled to all of the rights of any other spouse that they get as a dependent spouse or as a spouse of a married couple. If you have a spouse who is not a U.S. citizen, you can sponsor them because you can sponsor them for citizenship now because you're a United States citizen and you were married, and that's a federal program. So you can sponsor them for status and citizenship. The Department of Justice will talk about that if you have any criminal things going on. There are spousal immunities from having to testify against your spouse that do not apply to same-sex couples if they're not married. So there are Department of Justice and certain laws that will impact you favorably. All of these agencies look to the state of celebration, and if you celebrated your marriage in one of those 17 states or the District of Columbia or in Canada or another country that recognizes your marriage, these agencies are treating you as married no matter where you live. The IRS is another one, and this impacts my practice a lot because, as you may know, I do a lot of estate planning. 80% of my clients are in the LGBT community, and because of that focus of my practice, I am really intensely aware of some of the things that happen to couples who might have more income than, I want to say the rest of us, because it's not in my category, but what happens to their money and what can they do to maximize their fund. I'm sure Judy will talk about this in more detail when we get into the nuts and bolts numbers of it. But from an estate tax standpoint, if you're married and one of you is maybe you're both very well off and you exceed the estate tax exemption per person, which is over $5 million this year.
Yeah.
That's us.
I know we're all worried about it.
That's us.
You could probably skip that part.
Well, here's the thing I don't want to skip, and that's this. That's that if one of you should die and you're a married couple, that exemption can be stacked on top of your spouse's exemption, and there will be zero estate tax when the first spouse dies, even if you're Bill Gates, even if you have an enormously huge estate, because a married couple has an unlimited marital exemption. The thing to remember, when people hear that, go, all right, this is great, is that there's still going to be an estate tax to be paid, but it won't be paid until the surviving spouse dies. So it's just a wonderful perk for married couples that they can plan and they can do some estate tax planning that's more beneficial if they do have that marriage license, no matter where in the country you live. So the IRS has come down on the state of celebration. If you're married anywhere legally, then the IRS is recognizing you even when you live in Texas. That also means, let me back up and give you one more pointer about this. Those of you, and most of you have gotten married or are thinking about getting married, you now get to file a married tax return. You do not have the option of filing a tax return that says you are single. So it is mandatory that those of you who are now clutching that marriage license, that you have to file a tax return and claim your status as married. It can be married filing jointly, which most of you will find is going to be more favorably taxed than married filing separately, but you have to file as a married couple. The one thing that we need to at least mention is this. The Social Security Administration will not automatically provide benefits should one of you retire or die, spousal benefits, yet. And I say that yet, it's got to be qualified because they're still working on their administrative rules. And the Social Security Administration rules to date, long before same-sex marriage was even on the radar anywhere, their rules have always been to look at the state of domicile where the couple lived when they filed the application for benefits. And there are lots of Social Security rules that will look to the state's rules to see what the benefits are going to be. And unfortunately, right now, if you file an application and you live in Texas when you file it, their formal and official position is they will hold it. They won't outright deny it, but they will hold it pending further review because they look at state of domicile. You remember we talked a minute ago about looking at state of domicile or looking at state of celebration. They're not quite at the celebration state place yet. So if you get married thinking you're going to be entitled to Social Security rights, hold on. We're not there yet. So, people say, well, why shouldn't we get married? It sounds to me like it's all peaches and cream and we need to go do this and there's all of these benefits. And by and large, I think that's probably true. I think that's probably true. It doesn't mean you're any more committed. I mean, committed is committed, right? If you're into this relationship for the long haul, you're into this relationship. So are there any, I get this question all the time. Two questions that people call and ask me. One is, can I be fired for being a lesbian? And I ask them, I don't know, were you any good at it? Yeah, you're fired. Go over there and bat for the other team. The other thing that people ask me is there any reason we shouldn't get married? And it really is, it's a personal decision. It's a case-by-case basis whether or not you should be married. So there are actually some things in the law you should be aware of. The first is, you know that Texas is among the 33 states that will not yet recognize your marriage. So you're going to be married here, you drive to Oklahoma, you're not married in Texas, you're not married in Oklahoma, you're not married in Kansas, you keep going north, what? You end up in Iowa, you're married. You keep going north, you end up in Michigan, or you're not married. You go to Minnesota, you're married. I mean, you could just have these celebrations all across the country. So one of the downsides is that you have varying protection nationwide. Another downside is different agencies are ruling differently, like Social Security Administration. There's this big tug of war. Even though the Obama administration has been really supportive of same-sex marriage after the Windsor decision and has directed all of these various agencies to rewrite their rules and rewrite the implementation of their rules to include all married couples. And I think they've really pushed for a state of celebration rule as it is. There's still conflicting agency rules, particularly in Social Security, the Social Security Administration, so be aware of that. The other downside is if you are high-income spouses, this is not Utah, this is not polygamy, this is supposed to be Dallas. It's all of the beautiful women of the big country. But if you and your partner are both high-income earners, you know you're going to have to file a married filing jointly or separately tax return, and all of your income is going to be aggregated on that return. And I've had many a couple, not many, but I've had a handful of couples that have that problem, and they sit down and we look at all of their paperwork, and they go, it would cost us too much to be married. So think about this, and I always caution people to go talk to your accountant and see what your CPA or somebody who's familiar with all of your financial tax returns and your upcoming status, whether or not it would make sense to get married from a financial standpoint. I still think it's a matter of your heart, and if you want to show your commitment to your spouse, then maybe you're paying for your rights. But it is a personal decision. The other
So
thing
does-
is,
Let me ask this question, but so does other married couples, right?
heterosexual, you mean
Right.
heterosexual couples, that's right, it's the same thing.
I mean,
If
it's the
both
same thing.
spouses are working and making tons of money,
Right.
then they need to look at that. My experience is most same-sex couples, both the spouses are working. Many times, two men in particular, because there's always been this disparity between women's wages, and it's usually 76 to 78% of males' wages for the same type job. When you have two high-income men, they tend to pop that faster than a straight couple. I hate to stereotype, but in large part that is true. But you're right, it's
It's
the
not like a
same.
penalty, though.
Right, it's a marriage penalty, not necessarily a gay or lesbian.
Right, okay.
So, the thing also is if you have children, how many of y'all have kids? How many of y'all are raising children? How many of y'all are thinking about those kids going to college? Okay. How many of y'all are thinking that you might have to file applications for financial aid for those children to go to college? And what happens is, if you are married, both spouses will have to have all of their income included to see whether or not that child will qualify for financial aid. So it could be an additional factor, determining factor, or at least a consideration that you should look at before you tie the knot, is if you have kids that are going to be going to college and depending on financial aid, because they will look at both spouses and income. And then, of course, I think this is major. A lot of people don't realize you may be in a committed relationship that becomes uncommitted sometime, and one of you walks or the other one walks, or, goes a different path, and you want to walk away from terminate your relationship. You can separate your assets and you're through, unless you have a marriage license and you are still married. You might be separated, but until you go back to the state in which you were married or another state that will divorce you, you have to get legally divorced. So separated and still married also means that you can't marry anybody else unless you go dissolve the divorce. So a lot of people in our community are so not aware, because, for 50 years that I've known people in the gay and lesbian community, we never had to worry about it. Of course, I have lots of friends who have been together 40 and 50 years. Jack and George, how long have they been together? For at least that long. And whether or not they were married isn't even a consideration. But if you're thinking about it, there's been a lot of fluidity and a fair number of relationships in the LGBT community. And now if they decide they want to get married and tie the knot, you can't just decide you're going to snip that knot. You've got to go have it untied. So divorcing. And there are only a few states that will permit you to divorce without going and living in that state. A lot of people don't realize you go west of here and get married in New Mexico, and for whatever reason it doesn't work out. If you want a divorce, one of you has to go back and live in New Mexico for 6 months. There's no marriage, you don't have to live there. There's no residency requirement to marry in New Mexico, but there's a residency requirement to divorce. And the same is true with all but 4 of those jurisdictions of states that we discussed that has a residency requirement. So it's a factor to consider. Now, if you got married in Canada, if you got married in California, to name 2, and it doesn't work out and you want a divorce, those are 2 places, 2 venues that will allow you to divorce if the state in which you then reside will not recognize your marriage. So I don't think we have to worry about Reverend Walker and Monica. I don't think that they're going to be taking off their Canadian colors anytime soon and parting ways. It's just a factor that some people need to be aware of, is that you cannot just leave your relationship and be terminated your marriage. Hadn't happened yet. So, what's on the horizon? Anybody got their crystal ball? I didn't bring mine, so I'm not sure, but we do have a political primary coming up, and we're not going to talk a whole lot about politics, and I'm not going to suggest which way one might be leaning, except that it will have a huge impact on what direction this state goes. So I can caution you, first of all, vote in the primary, vote in the elections. We have to make our votes and our opinions known, if nothing else, to counterbalance somebody who might be voting the other way. And patience. Things are changing, maybe more slowly than some of us realize, but look at the progress we've made just in the last 15 years. 15 years ago, I used to be active on the board for the Human Rights Campaign, and 15 years ago, our strategies were trying to keep them from passing any more hateful legislation. So we were on defense all the time. We were on defense, trying to defeat matters. When President Bush was in the White House, they kept introducing these constitutional amendments. He was trying to get them to amend the United States Constitution to write us out of the U.S. Constitution by defining marriages between a man and a woman, something that's always been just a state prerogative to define the marriages for their states. He was trying to write us out of the federal Constitution. Had they succeeded, the Supreme Court could not have ruled the way it did in Windsor last June. So we played defense for so long. And one of the goals 15 years ago, for those of you who have been active in the community and lobbying and doing everything we can for our rights, one of our goals was to stop hateful legislation, and the other was to be more visible, let people know who you are, because now public opinion has shifted from like 20% of the people who used to be supportive of LGBT equality, and now there's over a majority. There's between 60 and 70%, depending on the age group of the people who are being polled, who support gay and lesbian couples being able to marry. So it's just been a phenomenal shift in the last 15 years toward equality. So patience, and frankly, I think history is on our side. I think we will get there, and equality is certainly the path we're on. I think it was Martin Luther King Jr. who said that the arc of the moral universe is long, but it bends toward justice. So we are headed in that direction. The other thing is there are lots of pending cases. I mentioned a few in Texas that are challenging the DOMA law in Texas. There are divorce cases. I don't know if you know this, but there are a few gay and lesbian couples who have gotten married and come back to Texas and have lived here and the marriages didn't work out, and they have filed in Texas family courts to be divorced. And the Attorney General, Greg Abbott, has intervened in those cases and said, Texas won't recognize that marriage, so you don't have jurisdiction to divorce them. And trying to keep people glued together, saying the only thing they can do, the only thing the court could do, was declare their marriage void from the outset, and so having no legal effect. That's the only way that he would see that a gay marriage could be terminated. Well, the unfortunate thing is a lot of these people accumulated property together, they've got kids together, they need to have a judicial order about the separation, just like any other married couple would have to if they were separating. So, Greg Abbott has intervened in some of those cases, and the courts have denied his intervention. So we've got some feisty judges on the family law courts in Texas. Well, 3 of those pending divorce cases have gone up to appeal. They're on appeal with the Texas Supreme Court. They were just argued this past November. So I suspect sometime in 2014 we are going to have some type of decision from the Texas court. Now you have to remember that Texas judges at all levels, whether it's the family law judges who had the brave guts to rule the way they did, or whether the Texas Supreme Court judges who are now considering these cases, they're all elected. They're all elected. And the majority of this state right now is still voting red. So I don't imagine that any of these justices who are either appointed by Rick Perry or have been voted on by the red majority, because they, the boundaries of the legislative districts in Texas have been gerrymandered to the point that it's made these conservative Republican districts safe right now. That's going to change when the governor changes. That's going to change when the state, like it used to be a blue state, it used to be an Ann Richards state, it used to be a Barbara Jordan and an LBJ state. There is going to be a future where we'll have different boundaries, and the Supreme Court is going to answer to all the people. But for now, let's say they rule in favor of Greg Abbott and they refuse to let these same-sex couples divorce. Where do those cases go next? The U.S. Supreme Court. Yeah, the U.S. Supreme Court. There are cases in Virginia that are already headed to the U.S. Supreme Court on the Section 2 of DOMA. I'm sorry, Section 3 of DOMA. There are already cases in other states that are postured, ready to go to the U.S. Supreme Court. So when the Supreme Court grants cert, it's called certiorari, to hear one of these cases, then I'm convinced that they will have to rule the remaining part of DOMA unconstitutional. So pending cases is going to be our next avenue toward equality. In the meantime, what are y'all supposed to do? You're living in a red state that doesn't recognize your marriage or your intended marriage or your domestic partnership. What can you do? Texas does recognize rights by contract. So you may be legal strangers in Texas, but you need to have these documents. I call them the Significant 7. There's a handout. It's got them listed on there. You've got to have a medical power of attorney that allows you to let your spouse/partner make medical decisions for you if you are incapacitated. How many of you all saw that movie, Bridegroom? Anybody?
Yeah.
That was not from the 1980s. That was like 2006. About these two young men from small towns, one in Montana and one in Indiana, I think, who met in California and had this storybook, soul connection kind of relationship. And they didn't have any doctor. They're 20, they're in their 20s. They're going to live forever. They don't think about things like this. You never know what's around the corner. And what happened is, one of them was injured, one of them ended up in the hospital, and the other was treated like a total stranger in the eyes of the law. No matter, I think they've been together 7 or 8 years, 6 or 7, out somewhere. And in Texas, even if you've been together 22 years, as some people in this congregation have been, you are legally strangers in Texas. You need to have a medical power of attorney and a HIPAA release, a patient privacy waiver it's called, so that your partner can make those medical decisions if you're unable to do so. And I put in mine, you should always use an attorney who is familiar with LGBT issues, by the way. My medical powers of attorney include additional rights that are not just in the generic statutory document that say, and my agent shall be able to visit me in any facility as if he or she were my next of kin. Mine are going to say that my agent can not only refuse medical treatment or permit medical treatment on my behalf, but can remove me, can move me out of a facility and move me to a different one, even if it's against medical advice, if they don't like the way I'm being treated in that facility. If you ended up in some little, rural podunk facility that wasn't going to let you have the kind of relationship and rights that you're entitled to, move them. My medical power of attorney has those kind of rights in it. So you need to have medical power. A statutory durable is called a financial power of attorney. It allows you to make business and financial decisions for each other whenever you, the principal, director, partner, or agent, to act on your behalf. The declaration of guardian isn't about children. There is a separate one for children, for those of you who have kids. But the declaration of guardian is a safety net so that if you are incapacitated, maybe recovering from some type of injury or wreck or something as happened. Tony and Jim, these two guys I represented a few years ago, were in New York, and Jim was hit by a cab, and he had a head injury. He was, an international auditor, bright man, but he couldn't tell you what time it was, much less be able to do his job and handle his financial affairs. And so Tony flies him back to Dallas, and he's undergoing treatment at the Pay Rehab Center for this brain injury he had. Jim's mom goes to the judge and says, Your Honor, I need to be appointed as my son's guardian. And a court-appointed guardian makes all the medical decisions, makes all the business decisions, and Tony's standing there going, what's happening? Because he had no legal standing, he had no rights, they had no documents. And if they had had a declaration of guardian in case of later need or incompetence, which is one of the significant 7 I think every couple ought to have, then Jim being incapacitated would not have been a problem because nobody could collaterally go to the judge and be appointed as the guardian. Tony could have stood in front of the judge and said, Your Honor, he doesn't need a guardian. I'm doing everything with these powers of attorney during this period, but if you think he needs a guardian, oh, here's the document. He wants it to be me. And it keeps a family member from being able to override those decisions with your powers of attorney. There's a case in Dallas, it was in The Voice probably just a few months, maybe 6 months ago, and these two guys, one who was became incapacitated, and they had a medical power of attorney and a business statutory durable power of attorney. And he became so incapacitated, his partner's taking care of him. The sister of the incapacitated man goes to the court. They didn't have a declaration of guardian form. She goes to the court and gets appointed as her brother's guardian and decides to take control of him, moves him, and sells the house. He had no recourse because they didn't have a declaration of guardian. You need to have this as part of your package. The directive to physicians In other states and in some places, it's called a living will. You're probably already familiar with it. Again, if you cannot communicate and you want to make sure that your wishes are carried out, should you be at the end of your life, it's a proxy vote. It's your way to have a proxy vote in case of later incapacity about what your end-of-life choices would be. You should have a directive to physicians. The appointment of agent to control disposition of remains. Some people are shocked to know this. You have no right to make funeral, memorial, or burial arrangements for your partner or spouse unless you have this document. Your body belongs to next of kin unless you have this document. You can waive your marriage license all you want to, but in Texas, you don't have the appointment of agent to control disposition of remains. They're calling mom and dad or your brother and sisters or somebody else to make funeral arrangements. So you need to have the appointment of agent to control disposition of remains. And everybody needs to have a will. If you don't have a will, the state of Texas has got it all mapped out what's going to happen, and your partner is not on the list of the map. They're not anywhere on that map. Things are going to go to your so-called next of kin. If you're legally married and the marriage is recognized, it would be spouse, but that doesn't count. So it's going to go to mom and dad, it's going to go to brothers and sisters, it's going to go to nieces and nephews. They will find heirs of yours. So if you want to be sure that partner is protected, that the house that you might own in both names, when you die, goes to the surviving partner, you got to have a will that says that. Otherwise, I had a woman who came to my office probably last year sometime. She and her partner, Michelle, had been together 25 years. They owned a house together. In fact, Donna owned it before they got together. She owned it like 26 years earlier. They refinanced it into both their names, and they thought they were perfectly protected. They had a life insurance policy and retirement benefits that named each other as beneficiaries, right? So those just go by beneficiary designation. But they thought the house, because it was in both their names, they were fine. They were protected. And Michelle was in she was in a charity bicycle race and got hit by a car, and it killed her. And Donna, unfortunately, at that point, comes to me because the brother and sister, Michelle's brother and sister who lived in Kansas, now owned half of her house. She didn't have a will.
Write a survivorship document too.
Well, you can have a joint tenants with right of survivorship document on the house as well, and that's like belts and suspenders. You still need to have a will.
Yeah.
Even if you have a joint tenancy agreement, you still need to have a will. Because what if you sell that house? A right of survivorship document, like she mentioned, is only going to be specific to that piece of property. But if you have a will that says, I leave all of my real estate, no matter where it is, wherever situated, of whatever kind, I leave everything to my partner, spouse, whatever you call each other in your wills, then something happens to you unexpectedly, he or she will get the house. So you have to have a will. In the will, you can also name who's in charge. Do you want mom and dad or brother and sister to be in charge? Or do you want it to be your partner? So partner can be both the executor and the primary beneficiary of your estate. If you have kids, you can have provisions in your will that say the children will have their share. If something happens to the both of us, will have their share put in trust until they get to be a little older. So you can have a contingency trust for minors. There's lots of ways that you can have it your way. So you might say it with flowers, but get it in writing. Do your documents. These are so significant in our community that if I could scream it and make it, rest heavier with you, it would. Because this really is a tipping point, not a cow tipping point, but a tipping point in our community. You have got to have these documents in the meantime until we get DOMA completely overturned and your relationship is recognized in Texas. You've got to have a significant set of documents. Thank you for your attention. What are your questions? One in the back. You're silhouetted. I can't see you.
I'll stand up, still probably won't be able to see me. I'm the biological mother, but she has legally adopted them in the state of Texas. Do we need to have any documents protecting the children?
Yes, there's, the Declaration of Guardian document that we mentioned here has to do with Declaration of Guardian for you. If you're later incapacitated, if you have children, you should have a Declaration of Guardian for your minor children till they turn age 18. And you two are married, you're not married, but you are both considered the legal parents of those children. Just to make sure that that relationship is recognized by the courts, and they have been upheld, incidentally. A second parent adoption in Texas has been challenged there's a 6-month window. If you challenge, a second parent adoption within 6 months, it might have a different outcome. But so far, we have over 3 courts of appeals that have upheld second parent same-sex adoptions. So you're on strong legal grounds there. But you need to, both of you, have a declaration of guardian for your minor children that says if something happened to the both of you, who you would designate as a guardian for them, it needs to match, who you would designate as a guardian if they were still under age 18. So in your wills, you need to have a plan that integrates the both of you. So, I'm the biological mother of these children. They were adopted by my partner on such and such a date, and in the background section of the wills that I draft, I declare that kind of information so the court knows you're educating the judge. The court knows this is not just somebody I met and's been a caretaker, this is the other parent for these children. And then you have a declaration of guardian for minor children to belt and suspender that to make sure that nobody will override your decisions about your kids. How old are your kids?
5 and 9.
5 and 9, you should do that. You sure should. Any other questions? Yes?
And y'all may have addressed it earlier, a little late, but seems like last summer there was a case where this guy was in the hospital and the partner was there with him, and then the family came in, and even though he had power of attorney, they arrested him and kicked him out, and would not let him back in.
Where was this?
I think it was in Oklahoma, or
Oklahoma?
maybe it was kind of the Midwest somewhere.
Well, I can speak to Texas documents, and each state has their own rules. I don't know about that specific case and what the rules are, but as I mentioned to you earlier, when I do a medical power of attorney in Texas, I take the statutory format that the hospitals and nurses and everyone is going to be familiar with, because I want it to be quacking like a duck and have a beak like a duck and be white like a duck and have them say, yep, that's a duck. And then they open it up and they say, and my agent shall be able to visit me in any facilities if they were my next of kin. It's got all these other rights in it. And here's the thing. There was a case in Florida a few years ago. I don't know if you remember this particular case. These 2 women had all the documents. They weren't from Texas. I think they were from somewhere in the Midwest. They'd adopted children together. And they were going on a cruise that left out of Florida. And they're down there when one of the partners just had a stroke or passed out or something. They call emergency. They're in Miami. She ends up at the hospital. They have their powers of attorney. And she goes to the hospital, and the hospital, the administration, or I guess she's just sitting at the reception desk, and she's looking at this power of attorney while the partner is rushed to the back for treatment. She goes, this is not a gay-friendly state, and we can't honor this document, and it might be a similar case to what you're talking about in Oklahoma, where it was in the discretion of the hospital personnel to decide what their policy was going to be about visitation. Well, the woman ended up in a coma. She's sitting out in the waiting room. Bridegroom, remember this is a similar situation in that movie Bridegroom, or that documentary that's been out. The same situation where the family's denying them access and the doctors and hospitals are denying them access, and she's out in the waiting room with the children while the woman gets sicker and sicker, and finally the doctor took pity on her and let her come back and say goodbye to her partner who ended up dying, even though she had a medical power of attorney. So she ended up being able to say goodbye right before the woman died. Well, I know this will probably shock you, but she sued him. Lambda Legal represented the surviving partner, because this was before they could get married. I think it was in 2008, might have been 2007 in Florida, sued him, and Lambda Legal was representing her, I think I said, and lost. Because the court ruled that the hospital had a right to set its own policies. After that judge's ruling, it so enraged so many people that the President, Obama, signed an executive order that said any hospital who takes a dime of federal money will recognize the partner if they have a medical power of attorney to make those kinds of medical decisions. So I don't know how old that Oklahoma case is, or the Bridegroom case that was 06 or 07, I think. But since 2008, by executive order, they've got to let you visit. They've got to let you make the medical decisions if you have a power of attorney. You can't just walk in there and say, well, I'm the agent and I'm the life partner. You've got to have a document that proves it because you're single in Texas. So since 2008, by executive order, hospitals must recognize your ability to make a medical decision and visit. So that's really important, that you have a medical power of attorney that has those things built into it.
Do we need the original power of attorney or a copy or what?
Copy works. If the document, I should say, that's why it's important to go to somebody who deals with communities and deals with the LGBT community, because my powers of attorney have language that says a copy of this document, the signed, notarized copy of this document shall be as valid as the original. And then I give people a letter, and it says, among other things, that you carry that. When y'all travel, you should have 3 documents that are in your suitcase with you. We've got them in the glove box of the car right now. It just says emergency documents. It's got the medical power of attorney, the HIPAA release, and the statutory durable power of attorney. So you travel with your powers of attorney, and they say a copy is as good as the original. So there's copies in Marty's car, there's copies in my car. We've got the same suitcase that always goes on a plane with us, and there's a little envelope in the bottom of that suitcase that's got both of our sets of documents in it. So a copy is as good as the original, if the document says that. So mine has a little provision in there that says a copy of this document is as good as the original. One more. We have one question here. Go ahead.
We looked at changing our names after we got married, or actually before that we wanted to change our names, and we found out we had to go before a judge and it was going to cost a lot of money, and then we couldn't even be sure that they would change it. I was wondering if, since this ruling on DOMA and the Social Security thing, can we present to the Social Security our marriage license and say, we want our names changed?
That's what I did last week. We did that.
You did it?
Yes. They were dragging their feet a little bit because it was still just the 9 counties in New Mexico, but then I talked to them 2 days ago and they said it should be on the way.
That's a good point. And I talk to family law attorneys that deal with, the adoption part of this. I don't do the adoption part, I do the estate planning and wills and I'm really good at getting people together. But the name change and adopting children and such. So I talk to my family law attorneys who do this. And I tell them, I say, I have clients who have gone somewhere and gotten married, and one of the women has presented at, in New York, for example, the Social Security number and had the judge go ahead and grant them a name change. So they've been able to do it that way. Is that legal? And most of the family law attorneys that I deal with say that it may or may not work for everything in Texas. You remember that fractured map I had up here? Unfortunately, there's still a lot of things in flux, and it's not exactly clear that if, like, a heterosexual couple could, the woman could, or the man, if he wanted to, I suppose, could get their name changed when they got married, whether or not it is recognized for all purposes is a big question mark. Most family law attorneys say you should still go through the legal process in Texas to do the petition for the change of the name of an adult. So, the question over here. Yes.
I guess when it comes to prenuptial agreements, I guess...
Prenups?
Yeah, I guess how does that work when it comes to the gay community or...
Well, that's a good question. Now, in Texas, this is a community property state if you're heterosexual couple. Because Texas doesn't recognize your marriage, I think a lot of couples are smart to do what's called a JPA, a joint property agreement, and do the equivalent of a prenup without calling it a prenup under the family code. And the few times that I have done these since, the laws changed in January 1, but the few times that I have done this in the past month or so, we've called them joint property agreements and said, we were married in New York or wherever on such and such a date, and we are intending to marry in New York on such and such a date. And then I put in there, it's a property agreement, so that is enforceable under Texas law regardless of your marital status, but it's not considered community property. As a community property state, a married couple can accumulate community property, meaning it's divided 50-50 between the couple if they ever should separate. You cannot accumulate community property as a same-sex couple, even if you're married, yet. So I always couch the prenups or joint property agreements as just that, as property agreements. And then if the marriage ever is recognized, we're going to do an amendment to that property agreement and call it then it's a postnup because you're already married. But I think it's a great idea to have a written agreement that's going to set out what your rights and responsibilities are for each other. Right here.
We have a civil union in Vermont,
Congratulations.
and so what does that,
You're single, and you have no federal rights with a civil union.
you're single?
I'm sorry. You're single. Unfortunately, that's been unanimously how the courts have ruled, and the federal government and all the agencies have ruled, is that you are still considered single. Not only in Texas, but for federal agency purposes. And most, a lot of employers are now required to provide spousal benefits to their same-sex married couples, and it does not apply to either domestic partnerships or civil unions. Because now you do have the right to marry in some states. Right behind you, yes.
I get, excuse me, I get federal benefits from my ex-husband as far as his Army retirement and TRICARE. If we went and got married in New Mexico and came back to Texas, even though Texas doesn't look at our marriage, then because of the Department of Defense, would they take those things away?
They would, in fact, because the Department of Defense will recognize your marriage or divorce, and if you're getting those benefits right now and you should remarry, according to the DOD, those benefits will stop because you remarried. Regardless of the fact that Texas will not recognize your marriage, DOD will.